Ready for court's dictation. 5 seconds. Start. The benefit of future prospects cannot be denied on the ground that the tribunal has assessed the income of the deceased on notional basis and that the claimants has not proved by documentary evidence the exact figure of that national income. Stop. Once an income is assessed by the tribunal for the purpose of calculation of the compensation, then it cannot be said that the same income is not the established income for the purpose of grant or calculation of future prospects. Stop. The tribunal cannot award any compensation to the claimants unless an income is proved before it as per the requirements of the Evidence Act. Maybe some approximation has to be done by the tribunal on the basis of evidence. Stop. Needless to say that the Evidence Act permits the oral evidence as well. Stop. Para. As stated above, the Honorable Supreme Court has used the phrase established income only as a phrase of linguistic expression and not as any rule of evidence, except as it has specifically clarified the same as meaning the assessed income minus the tax. Stop. It is well established that the judgment of Constitutional Court is a precedent only to the extent it clearly expresses it to be so. Stop. It is never a precedence qua that what could be logically deducted from the judgment. Stop. Still further, the judgment of a court is not to be interpreted like a statute so as to make an attempt to assign meaning to each and every word used in the judgment as part of judgment writing skills. Stop. No attempt can be made to find out the intention or to impute intention to the court which writes a judgment beyond what is expressly written or clarified by the court. Stop. Anything more than that would be governed by the relevant statutory law. Stop. Hence, the term established income or income established use in the judgment of the Honorable Supreme Court has to be read in context of the provisions of Evidence Act. Stop. Linguistically, established would mean as something in existence for long time. Stop. In terms of law of evidence, it would mean as something proved by evidence. Stop. The Evidence Act defines the term proved in section 3, which is reproduced here in as under evidence means and includes bracket 1 all statements which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry. Such statements are called oral evidence. Within bracket 2, such statements are called documentary evidence. Stop. A fact is said to be proved when, after considering the matters before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. Stop. Over.